Hello, everyone. Good morning, or good evening, or good afternoon, depend on what time zone you're in. My name is Rick, and I work with Jack and IP Law, a Chinese IP law firm. I've been working as a trademark attorney for more than 10 years. So today I'm going to be sharing some insight about the trademark field and some practical insight and some takeaways for you. So firstly, I'll be sharing my screen to start my presentation. Okay, I think I've already shared my screen. Please let me know if you see anything funny. One second, please. Okay, can you see my screen now?
Yes.
Okay, perfect. So in today's talk, we will be touching on some actionable insight in trademark where IP issues are real but manageable with the right approach. So firstly, here's the roadmap of my today's presentation, from trademark filing, prosecution to enforcement, with a focus on common pitfalls and practical strategies at each stage. And then we'll also touch on unfair competition and how the law interact with trademark rights in China. So firstly, when it comes to filing trademark in China, the golden rule is pretty simple: just file early and smart. Because in China, it operates under a first-to-file system, not first-to-use like in the US and other maybe common law jurisdictions. That means the first person or company to file a trademark application generally gets the right, regardless of who used it first. There's no requirement to show actual commercial use when filing, which creates a major opening for bad faith filer. We often see local individuals or entities registering foreign brand names, sometimes even before the brand enters the Chinese market. These squatter can demand payment or block the brand owner's application, or even sue the brand owner for infringement later on. This creates real challenges for global businesses that delay filing in China. So that's why timing and strategy are critical. If you're entering or even just thinking about Chinese market, securing your key trademark early on, preferably including Chinese equivalents or nicknames, it's highly recommended. Waiting until the launch of your product may be too late. Now, since we've just talked about first to use, let me quickly explain trademark use requirements here in China. When you file a trademark application in China, you don't need to show any proof of use. But once the trademark is registered, it must be actively used within a continuous 3 years period. Otherwise, the marks will be risking cancellation for non-use. And importantly, anyone, including your competitors, can file for that cancellation. So you may say that I only have my products manufactured in China and have no sales in China whatsoever. Can my trademark, if I file one trademark application here in China, can my trademark survive a non-use cancellation? The answer is yes. And here's the thing: use doesn't just mean sales inside China. Even if your products are only for export, as long as they are manufactured here in China and bear the registered trademark, that counts as legitimate use. While that means OEM manufacturing can protect your trademark against cancellation, provided you have all the right evidence preserved. So what type of evidence? Evidence like contracts, invoices, packaging photos, shipping records, custom records, or bank slips are helpful, but make sure they correspond and support each other. That's what we call the chain of evidence. So the key takeaway here is, if you're manufacturing in China and merely manufacturing here in China, you should also secure your Chinese trademark registration to protect you from being get into trouble. I think we all agree that China is still the manufacturing hub. So many brands have their products manufactured here in China through OEM arrangements. But let's be honest, business partner can sometimes be dangerous. In some trademark dispute cases, it's not random squatters, it's precisely business partners or suppliers or distributors who filed for the trademark in their own name. I've seen some cases where an overseas brand couldn't export from its Chinese OEM manufacturer because the brand, the Chinese, the trademark was registered by another Chinese manufacturer. So securing trademark rights in China isn't just about marketing or sales. It's directly tied to manufacturing and supply chain control. Brands really should file your application of trademark early, ideally before engaging any partners in China, and cover both the original mark and ideally its Chinese equivalents. It's just a very small investment, but it can prevent huge operational and legal hiccup later on. So now let's quickly go over the formal requirement of filing a trademark. Actually, it's quite basic. The applicant's name and identification. This could mean if you're a business license. If you're an individual, a passport of that individual. Then you will need to file a trademark, you will need a visual representation of the mark. And then you will need to choose the correct classification for your goods and services, and provide a power of attorney. Simply execute and send back the scanned copy will be okay. We don't need notarization or legalization. Well, let me say a quick word about visual representation of your trademark application. So as far as I know, this is unlike in many other countries. China doesn't really have the concept of a word mark. Instead, what you file for trademark application should exactly match what it is in use in the market. But in practice, the authorities allow some flexibility. That means if you file your trademark in a plain, regular standard font, you're using a stylized version that can usually be acceptable as long as the core elements stay the same. But one thing to be careful about when you file a trademark application and submit your visual representation is that please don't use fonts that may infringe on someone else's copyright. That's especially important if you're using a commercial or custom designed font. So when it comes to selecting goods or services for your Chinese application, you have to understand that China follows the internationally recognized NIST classification system. And China also recognized the TM5 listing. TM5, it's a standardized set of terms developed collaboratively by Europe, Japan, the US, and Korea. So this list helps harmonize classification and terminology across these major jurisdictions. So when filing a trademark here in China, the goods and service description must align with these accepted standards to ensure the application meets the requirements. Yeah, so we previously covered some of the formal requirements for trademark applications. Now let's move on to one of the key aspects that impacts how your goods and service are evaluated during examination, It is China's unique classification system. While China follows internationally recognized niche classification and TM5 listing, it has developed its own subclass system. Within each class, goods and services are further divided into subclasses, and some of these subclasses are split into groups. All of this is detailed in the Chinese classification manual, which is the main reference that examiners use. Unfortunately, this manual is only available in Chinese, and it updates from time to time, so it makes it very difficult for practitioners like us to make an English version, because you have to put in a lot of efforts in making so. Um, back to the subclass system. Goods and services in the same subclass or group are typically considered similar when it comes to examination. So it's important to note that the Chinese Trademark Office examiners rarely go beyond that menu when determining similarity. Sorry. So because of this, engaging a professional to review and structure a list of goods and services, it's crucial to avoid further issues. Okay, this slide is about claiming priority. If you claim priority from a foreign filing, there's a few things you have to take note. Firstly, there is a 6-month filing deadline after your initial application. That means when you file a trademark application in China claiming priority from an earlier filed foreign application, it must be done within 6 months from the day that of that initial filing. Regarding supporting document, you need to provide a certified copy of the priority document. This can be the document can either be submitted together with the trademark application or after filing, but within 3 months. If you choose the latter, you have to provide a hard copy. If you choose to file it together with your Chinese trademark application, a soft copy will do the job. And finally, the goods and service in the Chinese application technically have to align with the original application scope. If you claim border goods or service than those in the initial filing, you risk having your priority claim partially or even fully rejected. Now let's go over the types of elements eligible for trademark registration here in China. Firstly, the most common ones would be words, numerals, letters, and designs trademark. These are the most common marks. Second, if for it is also possible for sound mark or three-dimensional marks to be protected as trademark, and also color combinations like specific color pairing like Shell's yellow and red mark used in its gas station can be registered. There is a condition that this mark has to inherently have its own distinctiveness, and then you have to prove that your mark has acquired distinctiveness over time. So that's pretty important. If your mark hasn't been put into use in a very long time or in large scale, it would be very hard to gain registration for non-conventional marks, say sound mark, color combination marks, or three-dimensional marks. And lastly, any combination of the above elements can be filed as a trademark. That's what we call a combined or hybrid mark. In China, when a hybrid trademark is examined, each element actually is reviewed separately. This means the examiner will compare the word part the device or the graphic part, and any other elements independently against existing trademarks. If any single element is found to be identical or similar to a prior trademark, it can trigger a refusal of the entire application. So to give you a practical example, you can refer to example that I listed here. If in example one, we can see that the graphic element of a hybrid mark that conflict with two early marks, right? And in such case, it will usually be a good chance of successfully arguing the similarity during the review process and overcoming the refusal. On the other hand, just take a look at example 2. In this example, the word element conflict with a prior prior application. In this case, the likelihood of successfully overturning a refusal will be much lower. So in summary, understanding how each component is assessed individually is crucial when preparing hybrid marked applications. Now let's take a look at the key substantive requirements for trademark to be registered. First, your trademark has to have distinctiveness. A trademark must be capable of identifying the source of goods or services. It should stand out and not be generic or descriptive without acquired distinctiveness. Second, its lawfulness. Your trademark cannot violate public order or morals. For example, offensive or inappropriate terms will be refused. Third, it's non-conflict, which is what we call the relative grounds. Your trademark must not conflict with existing rights. This includes prior identical or similar trademarks registered or filed in the related goods and services. Additionally, marks that contain deceptive elements such as false geographical indications or misleading features will be refused. A good example is now environmental terms like green are often viewed as misleading unless there is a clear evidence supporting the claim. We represent a client in this case. The client's trademark is called Frank Green, and it is used on bottles. We did manage to overcome the refusal in that case, which is usually this type of refusal is quite difficult to overcome, but we managed to get through it. So there is still hope. If we can present strong evidence supports the trademark's legitimacy. When applying for a trademark in China, there are actually two routes: the international registration route and the national filing route. The international route is done through the Madrid system, which allows applicants to file a single international application based on home country registration or application. This international application can designate multiple member countries, including China, so that will simplify the whole process if you're filing in multiple countries, jurisdictions. The timeline for this route is usually around 18 months from filing to registration. Of course, this assumes that no refusal is issued. In this route, the goods and service scope is limited to what your basic foreign application or legislation. There will be inherently some uncertainty because in the international route, the Chinese Chinese examiner will translate and interpret the goods and description from your original application, which can sometimes misclassify the scope. In contrast, the national filing route involves filing directly with China's trademark office. This generally takes a shorter time, about 12 months to complete. So likewise, this is under the assumption that no refusals are raised. In the national way, we can list any goods or service under the niche classification or TM5 listing. That means offering more flexibility. To summarize, the national route offers broader goods coverage and a faster timeline, while the Madrid system simplifies multi-country filings but can involve some limitations or uncertainties in terms of goods and service scope. So, yeah, this is the first part of my presentation, being the formal requirement and substantive requirement for filing a trademark here in China.
Thank you, Rick.
Oh.
Actually, what's really interesting
Yeah.
to have really important insights about the Chinese legislation on trademarks. For example, when we were talking about the Madrid system, I just, of course, noted that I didn't actually tell you about that. Peru is not part of the Madrid system. Actually, Colombia is part of the Madrid system, which is the only country in the Andean region that is part of this agreement. But there is actually a current trend that
Yes.
many countries are being part of this system. So eventually, I guess in the next few years, maybe Peru could be part of the system, which actually, as you said, has or actually helps applicants to get faster trademark application processes. So, well, thank you, Rick, for your presentation in this first section.